Thomas.
Good morning.
Good morning again, Mr. Green. So what we're going to do here is that I see both sides in this circumstance. I understand the arguments being made about why the standard as such regarding media might not necessitate the type of discovery being requested. I also understand the alternative statutory construction and why, given that construction, if it is correct, that the discovery would be necessary. So what we're going to do instead is that instead of simply bifurcating this case, we're going to be trifurcating this case. The first issue, and I know that Mr. Thomas's opening brief is due imminently, but I actually believe that this is going to already be encapsulated likely in what you're already working on, which is I want this issue about what's the media to be decided first. It'll be in essence like a summary judgment motion asking for the proper statutory construction as applied to this case to be determined. So this argument about the statutory construction and who is the media that was going back and forth in a motion to compel, I believe both sides have good faith arguments. It's an interesting issue. It's not one that I want to be making a ruling on a 1 week turnaround motion, given that it's potentially dispositive in this case. And so, Mr. Thomas, if you want to be viewing your opening brief here as a motion of, however you want to style it, I think it doesn't really matter what the caption is, but all the current dates are still set. What I want to hear from you is why you believe your statutory construction about why this type of media entity counts as media in this context is appropriate under the statutory construction. Then I'll hear from Mr. Cornelius why he believes his construction is correct. And then we'll have the reply brief and we'll have the hearing. At the end of that hearing, one of two things will happen. I'll either agree with the plaintiff, in which case I'm not going to be ordering that discovery. Likely, I'm not going to preordain what that ruling would be, but that's the likely outcome then. Or if I agree with Mr. Cornelius, I will then be ordering most of the discovery, but not all of it. And we'll cross that bridge when we get there. So I think that adequately weighs the different considerations. It throws a little bit of a curveball at the plaintiff, but I believe that your briefing was likely already going to be flushing these issues out, given that the motion to compel forced this issue already. So does that make sense to everyone? Mr. Thomas?
Yes, Your Honor, if I may, I have one extra day in order to make the modifications to the opening brief. This is something that...
And you can stop explaining, because I agree with you, if that's reasonable.
Okay.
Everyone will get bumped 1 day. So everyone has one more day to file what they need to file in this case. And we don't need to write an order for that. The record will reflect it. I'll ask the clerk just to put in the minutes that each party gets 1 more day to file their briefing here.
So that'll be Monday?
Yes.
And if I may just clarify real quick, just for my own clarification. So in the brief that I'm to turn in on Monday, this court wants the issue of why Mr. Green is media or not media as the first issue, first and foremost in that brief.
And actually, it might be helpful for you to lay it out that way to give us some context,
Okay.
But I'm not going to be ruling at the end of that this round of briefing whether Mr. Green is or is not media, because if I agree with Pierce County's construction, that will necessitate some discovery to see if he satisfies that standard. So this is really an intermediate step in terms of what is the standard for media under Washington law. Obviously, in the end, we're going to be applying that to Mr. Green, so it will be very helpful, I think, for you in terms of convincing me to view it through that lens, but in the end, I'm not going to give a thumbs up or thumbs down to Mr. Green as media. What I'm going to be doing is saying, this is what the standard is for under the proper statutory construction for media. And then the next round is going to be whether or not Mr. Green is in fact media. That might be a moot point if I end up agreeing with the plaintiff's construction of the statute. And so maybe we won't need another round if I agree with you. But if I agree with the statutory construction that Pierce County has articulated, then there will need to be some discovery. And the reason why I'm doing it this way, which might be a little more complex than necessary, is I understand Mr. Green's resistance to turn over highly personal information. But obviously, Pierce County has a right to defend itself, and if this in fact is relevant to these considerations, then it's something they're entitled to obtain. So I'm trying to weigh both things. I don't want to make Mr. Green turn over anything unless it's really necessary to resolve this case. And before I can decide if it's necessary, I want to make sure everyone has a full and fair chance to put forth their best arguments about that.
Then a secondary follow-up clarification question. Does this court also want the plaintiff to argue that whether there's a violation of the Public Records Act or not in this brief? Or is that at a later hearing?
I'm not going to be saying whether or not a violation occurred at this point. But again, I do think in terms of styling your briefing, that giving that context of what this case is about and looks like and what the violation you believe is going to be helpful for me to view these issues not in a vacuum.
Okay.
Mr. Cornelius?
Just to clarify, so we will both be submitting briefs on Monday.
Actually, you're not going to be submitting briefs on Monday, so thank you for asking. Mr. Thomas will be submitting an opening brief, in essence saying, here's a motion that says that I'm right about the statutory construction and what's media. Then you'll be filing a response saying, no, actually, here's the right way you should look at this, and then you'll have an opportunity for reply, and we'll hash that out at what was to be the merits hearing, and now we'll, let's say, the media issue hearing.
So I think we keep the same scheduling, but everybody gets an extra day. You get an extra day.
Okay.
That works for everyone?
Yes, thank you.
Okay, so that's what we're going to be doing. Looking forward to getting the briefing, an interesting issue, and everyone have a good weekend.
Thank you, Your Honor.
Anyone else here for my civil motion calendar rather than the unlawful detainer or anything else calendar? Okay, I am in recess and we are off the record.